Now, for veterans with an attorney or other representative who's helping them prepare for hearing, what are some of the things veterans can be looking for in preparing for hearing to tell if their representative is doing a good job? What are some of the things we do especially to help prepare?
Sure. Well, it depends a lot on the complexity of the case. Some veterans have a large number of claims that are going to need to be covered. Others may have only one. It just depends. But the process remains the same. For each claim, the veteran and the attorney need to discuss that, obviously prior to the hearing, figure out what pieces are important to explain to the judge. Remember, just these three elements. You have to show something that happened in service that caused the problem, you have to show the current problem, and you have to have the medical evidence connecting them.
Welcome to the Victory Over VA podcast, a podcast about empowering veterans to overcome denied disability claims. Each week, we deliver critical insights to help you understand the disability process, veterans' benefits, and how to take control of your legal rights. Now here's your host, Attorney Francis Jackson.
Welcome to Victory Over VA, our podcast to help you unlock your veterans' disability benefits. If you're a veteran applying for benefits, be sure to subscribe for the latest developments in VA disability. I'm Francis Jackson, and this is Christian Terrison, and we work at Jackson and MacNichol, a law firm that is dedicated to helping veterans get justice in their claims for the VA. Today, we're going to talk about how to prepare for hearing with the Board of Veterans' Appeals. Let's take it away.
All right. So I guess to start with, can you give an overview of what the Board of Veterans' Appeals, or BVA, hearing entails and what veterans can expect?
Sure. The purpose of a hearing at the board is for the veteran to have the opportunity to explain to the veterans law judge the facts and circumstances of the claim. So just take as an example someone who is making a claim for a disability involving their back. And to use an example from a case that we handled, we had a fellow who was injured when he was working in a small compartment in an airplane, putting in the parachutes or taking out the parachutes, I forget which now, but he had to kind of contort himself in to get into this space, and in the process, he injured his back. Now, the VA took the position that, well, it's just one of those things where he had a minor problem and it all healed up and went away, and it's not really why he now has a back problem. So he had to explain to the veterans law judge that, first off, he had injured his back. Second, it was far enough back in time that it was before MRIs. So for those of you who aren't aware of this, before MRIs, it was not possible to tell if there was an injury to anything other than the bones. They could look at bones with an X-ray, and if you had a broken bone in the vertebrae in your back, they could tell that. But anything short of that, damage to the discs, for example, they couldn't tell that without an MRI. So because this is far enough back in time that MRIs weren't available, nobody could really tell whether there had been damage done. But despite that, the VA took the position that, oh no, you just had a minor problem, you went to the infirmary a few times, and after that you were out of the military and you were fine. Well, in fact, what the veteran explained to the judge was that no, he hadn't been fine. He had gotten out of the military shortly after this happened, but he didn't have insurance. He was just out of the military and not employed in a highly paid occupation. He couldn't afford to go and get medical care, and he just lived on aspirin. So what the purpose of the hearing is to explain to the judge the circumstances that help to establish the three elements. You have to have an injury or illness in the service, some event that causes the problem later. You have to have a current disability, and you have to have a medical opinion that ties those two things together, says that yes, the current disability is related to what happened in the military. So the entire purpose of the hearing is to put in front of the judge the current disability, the facts about what happened in the military, and to submit a medical opinion tying those together. And what we find is that the reason a lot of these cases come to us and are being appealed and are going to the board is that when veterans present their cases to the regional office, which makes the initial decision on a veteran's disability claim, they don't understand how these three elements come together. And most of the time, the veteran either doesn't understand the need for or isn't able to get the medical opinion tying these things together. One of the things that we do most often in our office is help veterans to find an expert who can give a medical opinion explaining how these things tie together. So to come back to your question directly, the entire purpose of the board hearing is to explain to the judge how those three elements come together, what happened in the service, what the disability is now, and how they're related.
All right. And there are a few different options when you're seeking review by the board. And I know that under the legacy system, we almost always wanted to go for a hearing before the judge. But how can veterans decide whether they want to request the in-person hearing, video hearing, or just, written submission to the board?
Well, under the AMA, which became effective back in February of 2019, there are, as you pointed out, three review lanes with the board. You can simply ask the board to look at what happened in the regional office and decide whether that was correct. That's called direct review. You don't submit any new evidence, you don't testify, you just ask the board to look at what happened and see if it was right. Unfortunately, that is rarely effective. Most of the time, the board looks at what the regional office did and without any new information comes to the same conclusion, which is not surprising. The second possibility is what's called the evidence submission lane at the board. And in that approach, what you do is you take what happened at the regional office, but you present to the board additional evidence in written form. And it can be an affidavit from the veteran or from someone who knows the veteran, a so-called buddy statement, meaning a statement from someone who served in the military with him and knows the facts of this particular instance. Or it can be a medical report or a vocational report or any combination of those things. You can, anything that you submit in writing can go in this evidence submission process. And what happens in those cases is you file your appeal, you submit with it or within a few months after the written evidence you want the board to consider, and then you just wait for the board to get to it and they make a decision. The third option, and one that we always used to use in the legacy process, but it's not as necessary or helpful, however you want to phrase that, in the AMA process, is an actual hearing before the board. Now, we do that in legacy cases still because that's an opportunity for the veteran to kind of make a connection with the board judge and to explain all the details of what happened and how it happened and help the judge to understand why the veteran is entitled to the benefits he or she has applied for. And we do that in legacy cases because in those cases, the judge that hears the case is obligated to make the decision. Now, it seems intuitive that the judge that hears the case would make the decision, but in fact, in AMA, one judge can hear the case, and another judge who hasn't heard a word of it may end up making the decision. And for that reason, we're looking much harder at written submissions in these cases than we used to when it was all legacy cases. But those are the three options: direct review, evidence submission, or an actual hearing.
And can you talk a little bit about the virtual hearings versus, video hearings out of the regional office versus trying to have an in-person hearing too?
Sure. There are three possibilities for hearings. You can have, as Christian just mentioned, what's called a virtual hearing. And that's the easiest for most people. You can simply be in your own home with any device that has a video link and a camera, a smartphone, a tablet, a computer, doesn't matter. As long as you can send video and sound, it will work. So what will happen is there'll be a split screen presentation. Our attorney will be on, the veteran will be on, and the judge will be on. And of course, if there are any witnesses, they'll be on with either the attorney or the veteran, depending on how things are laid out. But the veteran will be able to see the attorney and the judge will be able to see the veteran and the attorney will be able to see the veteran and the judge. You get the idea. So that's one possibility, and we do that a lot. A second possibility for those who aren't comfortable with technology or simply don't have a new enough phone to use that, or don't have a tablet or a computer, there's a possibility that you can go to the VA's nearest regional office and they will put you on the computer, get the video going so that the veteran can simply participate from there. It's still a virtual hearing, but the veteran doesn't have to provide the technology. The VA will provide the technological link. And sometimes, not always, but sometimes we can arrange for having that done from someplace other than the district office, another VA facility that may be closer to where the veteran lives. As you can appreciate, there are some states where it's a big state and the veteran may be a long ways from the regional office. But the third possibility is an actual physical hearing. You can go to the board's office in Washington, D.C. and appear there. Sometimes the judge is there in person, sometimes the judge is still over video, but the veteran and the attorney can be right there at the board's office and do their presentation. Obviously, for people who live far from Washington, that's not the best choice, but it is a possibility for those for whom it's practical.
And this was more common when we were traveling to do hearings at the regional offices, but many times veterans would bring, paperwork, medical records, things like that with them to the hearing. Can you talk a little bit, especially about under the AMA system, if there's other evidence, how that can be submitted, and if there's anything that a veteran should bring with them if they're choosing to appear at the regional office for a hearing?
Sure. If a veteran is choosing to appear at the regional office, there's not much point in bringing things to the office with them. It's not a bad thing, but it doesn't really add. The way the hearing system works under AMA, the judge can consider any evidence that was in the record at the time the regional office made the initial decision on the claim. But he can't consider anything that was submitted between that time and the time of the hearing. So if there's anything that was discovered or was created in terms of medical evidence, later visits, x-rays, MRIs, whatever, that came into being or came into the possession of the veteran or his or her attorney between the time that the regional office decided the claim and the time of the hearing, what you have to do is you have to submit that again, even if it's already in the record. You have to submit it again in the 90-day window immediately after the hearing. So you have this 90-day period from the hearing to submit any additional evidence. And that can be any kind of non-testimonial evidence. Testimonial evidence has to go into the hearing, but you can put in a written statement from the veteran, written statement from other people, medical records, medical test results, vocational evidence, whatever it is. You have a 90-day window following the hearing to submit that. And so whether the veteran brings it to the hearing is kind of irrelevant, but the important part is that the veteran gets it to his or her attorney to be submitted to the board within that 90-day window.
Now, for veterans with an attorney or other representative who's helping them prepare for hearing, what are some of the things veterans can be looking for in preparing for hearing to tell if their representative is doing a good job? What are some of the things we do especially to help prepare?
Sure. Well, it depends a lot on the complexity of the case. You know, some veterans have a large number of claims that are going to need to be covered. Others may have only one. It just depends. But the process remains the same. For each claim, the veteran and the attorney need to discuss that, obviously prior to the hearing, figure out what pieces are important to explain to the judge. Remember, just these three elements. You have to show something that happened in service that caused the problem, you have to show the current problem, and you have to have the medical evidence connecting them. Usually, what we're submitting after the hearing is the medical evidence connecting those things, but that isn't always the case. Sometimes with PTSD claims, for example, in those cases you have to prove what the VA calls a stressor, meaning a stressful event that led to the development of PTSD. And sometimes difficult to show those facts, particularly when things happened a number of years ago that led to the condition. Unfortunately, with PTSD, people sometimes kind of struggle along for quite a while before it's recognized that the problem that they have is PTSD. And so it becomes difficult sometimes to reconstruct and document the events, but that is typically the other piece besides getting the medical evidence that is the challenging part. So the conversation with the attorney and the veteran is going to be about, okay, how do we prove what happened in the service? Usually that's the veteran's testimony, but as I mentioned, there's a special rule about PTSD and you have to have other evidence essentially. And then in addition to the veteran's testimony, you can offer the testimony of anyone else that has information that may be helpful to the judge. Often it'll be the veteran's spouse to talk about the severity of their particular symptoms, especially with mental health symptoms. That's often very helpful. But even with physical symptoms, it can be very helpful. So if it's not a spouse, it could be another family member. It could be someone who knew the veteran in the service and has information about what happened. It can be anything, but that information needs to be presented to the judge either in written or testimonial form. So the preparation for that is obviously discussion between the attorney and the client about what needs to be proven and how it's going to be proven at this particular hearing. But that's the essence of it. It's getting the attorney and client together to talk through what needs to be proven, what the available evidence is, how that's going to get presented, whether it's going to be in written form or testimony, whether it's going to be the veteran's testimony or someone else or both. But that's the essence of it.
Yeah. I know in cases I've worked on, as you mentioned, variable how intensive the prep will be, because sometimes if it's a service connection issue, and the VA recognizes there's a condition, and it's just a matter of proving that it's connected to service, that becomes sort of an expert fight, where it's, reviewing the attorney's job to carefully review the CMP exam and find all the problems, everything the examiner overlooked, any mistakes there, and then, getting an outside expert's opinion on, how there is service connection there, and the veteran's testimony plays a minimized role versus, if you're going for an increased rating based on especially psychiatric symptoms. I might spend, an hour on the phone with a veteran, talking with their spouse, just about the symptoms, the progression of symptoms, things like that. So depending on what's at issue, prep can look different for different cases.
That's right. It varies from case to case. In some instances, particularly in instances where there is now a good expert report that the regional office didn't have. Sometimes, if it's just a service connection issue, really, it'd be brief testimony from the veteran and submission of the report, and that will carry the day. Other times, as you said, it can be much more complicated.
And we are almost out of time for today, but for last question, I just wanted you to go over what veterans can expect from the Veterans Law Judge, or VLJ.
Sure. In a typical hearing, the way this will all go is there will be a pre-hearing conference, which is not being recorded. At the pre-hearing conference, the judge will confirm that this is the veteran, that he or she is going to testify. We'll find out if there's anybody else that's going to testify, most frequently a spouse, but can be anyone. And we'll talk about what the issues are and what evidence is kind of missing from the record that should be submitted to support the claim. Once that pre-hearing conference has been done, it usually takes just a few minutes, but sometimes it can be a little more complicated, especially if there are a lot of claims. But once the pre-hearing conference is done, the VLJ, the Veterans Law Judge, will start the recording. It will swear in the veteran, and it varies from judge to judge, but usually they'll swear in anybody else that's going to testify right at the beginning. And then they'll go on the record. That's an opportunity for the attorney to make an opening statement to the judge, simply explaining what the issues are, what the testimony is going to be, and how any other evidence is going to be handled. For example, Your Honor, we'll be submitting a medical report showing the connection between what happened in the service and Mr. Jones' current problems, and we'll be submitting that in writing after the hearing. That would be a common thing to be saying to the judge at the outset. So once you have made the opening statement, once the attorney has made the opening statement, then typically it will be question and answer with the veteran or the spouse or whoever else may be giving evidence. And once that's been completed, typically the judge may have some questions just to clarify things in his or her own mind about exactly what one issue or another may be. There will not be any cross-examination like you see in television shows where someone tries to destroy the veteran's testimony by asking him all these complicated and confusing questions. And then once the testimony has been completed, the judge will typically offer the opportunity for an additional closing statement to kind of summarize what's been said and what, if any, further evidence is going to be submitted post-hearing in the 90-day window. And then the judge will close the record, and that'll be it. Some veterans find it a little intimidating to be sworn to tell the truth, but it's not a big deal. As long as you tell the truth, it's no problem. And, but some people get concerned because they're talking about events that happened a long time ago. They can't remember exactly how things happened, and it makes them nervous to be under oath to talk about it. But that's one of the things that we would typically cover in the preparation for the hearing, explaining that you are going to be under oath. That doesn't mean your testimony your memory has to be perfect. You just need to explain what you remember, and if there are things you don't remember, you say that. It's not anything terrible or intimidating.
As elsewhere in life, honesty is the best policy.
That's for sure.
But that's all the time we have for today. Thank you very much for tuning in to this episode of Victory Over the VA. Please be sure to like and subscribe, and join us again next week.
We'll look forward to seeing you then.
Thanks for joining us this week on the Victory Over VA podcast. Make sure to visit our website, veteransbenefits.com/podcast, where you can subscribe to the show in iTunes, Spotify, or via RSS, so you'll never miss a show. While you're at it, if you found value in this show, we'd appreciate a rating on iTunes, or if you'd simply tell a friend about the show, that would help us out too. If you like this show, you might want to check out our free consultation to see how we can help you with your denied claim. Simply go to veteransbenefits.com and fill out the form. You fought for us. Now let us fight for you. And be sure to tune in next week for our next episode.